So, dear ladies and gentlemen, welcome to our next session, which is held on law and economics of pricing. At the beginning, we would very much like to take the opportunity to thank Boris very much for making this event happen and for inviting us to this panel. I will start off with introducing my panelists. On my left-hand side, there is Stephen Mavrogiannis. He's a partner at Sherman & Sterling, and I really may say that he's a renowned expert in competition law, basically treating all kinds of issues which might come up in particular in international transactions. He's the author of numerous books, and something which is maybe also very important, in particular in Croatia, with the view to joining the European Union. He's also an expert on the European state aid regime. The next speaker will be then Justin Combs. We are very happy to have an economist on our panel. Justin is a director in Compass Lexen's European competition practice. He has 20 years of experience in competition law, and something which I want to mention in particular is that he knows both sides of the coin, since Justin was also a director at the Office of Fair Trading, and he even has been working with a regulator in the UK, with Ofgem, which makes him in particular best placed to speak about abuse of prices, since this is something which is very important also for regulated industries. Last but not least, we have Paolo Palmigiano. Don't play any tricks on him. He really is the one who has been sitting on all sides of the table so far. Currently, he holds a position as General Counsel in Lloyds Bank's competition practice. Before, he has heading the competition practice of British Telecom. As Justin, he has been working with a regulator. He was even the General Counsel of the communication regulation in the UK. He has been also in private practice. And something which is really remarkable, he still has a toe, or even more than a toe, in the regulator. He's a non-governmental advisor to the Office of Fair Trading in the UK. So I'm very pleased to be on the panel with these renowned speakers. And we would now really directly turn to the subject, which is law and economics of pricing. At the very beginning, I would like to invite you to look at the topic from two different angles. The one is the view from a non-dominating firm which might want to attack the pricing policy of a dominant supplier, competitor, or even customer. The other angle, of course, is the view of a dominating firm who really should know the framework provided by competition law in order to get its pricing policy right, and in order to be able to base, in particular, investment decisions or other marketing decisions on a pricing which in the end holds true also before courts and may not be challenged by any competitors. So, which is the right price? I can tell you the answer is really easy. The price, of course, may not be too high. However, it should also not be too low. Beware that it's not discriminatory and not predatory. Sometimes the price may even not be fixed, which is in particular astonishing. And finally, in any case, it should not be coordinated, but this was a topic of another session chaired by Mark Ryson. Where should be the answers? The answers should be found in a regulatory system. This is just for you to get a very broad overview. You will hear every detail then from my colleagues. Of course, it's Article 102, forbidding abuse of dominant position. We have then, and this is in particular important in abuse cases, a decisional practice, where, of course, the European Commission and the European courts have a certain lead. But since it is possible under the EU regulation that specific regulations apply to dominant undertakings on a national level, it is also always really very important to look at the national decisional practice, which can, in the case of abuse of dominant cases, deviate from the European model. So this is really an important thing to know. You cannot only stick to the European models in this case. Of course, there is a guidance paper by the European Commission, which there is a speaker from the European Commission, but I will say it nevertheless, which deviates a little bit from the court practice. But this is maybe what makes life interesting, in particular for lawyers. Just again, a very broad overview. We will talk about excessive pricing. It's of course self-evident that excessive prices could constitute an abuse of a dominant position. Something which already is a little bit surprising, that prices which are too low also can be an abuse of a dominant position in case of predatory pricing. To cut it brief, predatory pricing takes place if an undertaking sells, and dominant undertaking sells its prices below the costs of purchasing. Margin squeeze is a tricky thing, applies in particular to vertically integrated undertakings. And last but not least, something which is very important is, and which is also astonishing for many undertakings, that even rebates, which usually should be a good thing and should also help the consumers, can be abusive to some extent. My colleagues will then also tell you something about the court practice and what the court has said. I will only, for this time, present some things which might be astonishing. One thing which really strikes and has struck the community is that the court has held that even it is for dominating undertakings, it is not allowed under all circumstances to follow the prices of their competitors. So you might well have a situation where a dominant firm has to stick with a certain level of prices at the same time looking at his competitors charging lower prices and getting market shares. So these are some of the quite astonishing outcome of the court decisions. Since we are late, I stop myself here, and I'm in a comfortable position to hand over now to Stephen, who will answer some of the little questions already raised.
Okay, thank you.